business with the appellate commission draw near, give your attendance, and you shall be heard. Please be seated.
First, we'd like to give a special welcome to Professor O'Donnell's Advanced Appellate Advocacy class. We are very happy to have you here. Okay. There is more than 6.5 hours of argument time requested. Therefore, only ask for the time that you need, not the time that you wish. If we have further questions, we'll keep asking. People versus Kevin, appellant. Okay, that is submitted. Velasquez versus New York City Transit Authority. There's no respondent. Do you want to submit or do you want to argue? Submit? Okay, it's submitted. Sharita versus Hogarth is submitted. 163 West 48th Realty versus Sunflower.
3 minutes for appellant, Your Honor.
Sure, 3 minutes. Zurich American Insurance versus Altera American Insurance, appellant.
Appellant, 9 minutes total, 2 minutes for rebuttal.
Respondent.
5 minutes, Your Honor.
I'll give you 7 and 1, and I'll give you 5.
Thank you, Your Honor.
People versus Conyers, appellant.
Requesting 6 and 2, please.
Respondent.
6, Your Honor.
6 and 1 and 6. People versus Hines, appellant. Respondent.
6, please.
6, 1 and 6. Cusimano versus Super P57, appellant.
Appellant, 8, please.
Respondent. 6, 1 and 6. Big Notes versus Prousse, appellant.
Appellant Mark Basnade, happy for 5 and 2.
Respondent.
5 minutes.
5 and 2 and 5. Prospect Resources versus Levant Capital, appellant.
Appellant, 5 and 2, please.
Respondent.
10 minutes.
I'm sorry, how much were you asking?
10 minutes.
So I'll give you 5 and 2 and 6. 213 West 23rd Street versus Crunch Holdings, appellant.
6 and 2.
Respondent.
5, please.
6, 1 and 5. People versus Michael Martin, appellant. That is submitted. Hart versus Kappa, appellant.
Appellant, 8 and 1.
Respondent.
5 minutes.
5, 1 and 5, and we will be calling that case first today. Ahmed versus UPS. Respondent. Do you wish to submit it? Ahmed versus Pasternak. Do you wish to submit?
3 minutes, please.
Do you need 3 minutes? 2 minutes. People versus Williams is submitted. Castle Village versus Girardi, appellant.
8 and 2, please.
Respondent.
5 minutes.
I'm actually going to give you 4, 1 and 4. People versus Jackson, appellant. Respondent.
For the respondent, 5 minutes, please.
6, 1 and 5. Castellanos versus City of New York is submitted. So our first case for argument today will be Hart versus Kappa, and Justice O'Neill Levy is disqualified.
Step up.
May it please the court, my name is Stephen Brower of Schwartz, Conroy, and Hack, and I represent the plaintiff appellant Penny Fern Hart. At the outset, I'd like to remind this court that its review of the trial court's decision is de novo. We cited several cases in our opening brief for that proposition at pages 7 through 9. This court has the authority to review questions of fact as well as law. to promote substantial justice and to render whatever decree this case requires. This court should not.
Counsel, notwithstanding that, how do you propose that we deal with the fact that your client signed a document allowing Mr. Kappa to transfer the entire joint account into his sole name? How does she have any claims remaining after having done that?
So there's no question that the transfer was done voluntarily.
Okay?
A voluntary transfer does not mean that it's a gift, and it doesn't negate a cause of action for conversion. Conversion is the wrongful withholding.
Well, how could he convert it if she agreed to transferring it into his name? How could that be a conversion?
Again, she voluntarily transferred it, but she didn't, it wasn't a gift. And what's dispositive about...
This was a trial where the court made credibility findings, and based on the fact that she did sign a document transferring it, and there's no real contrary evidence other than her statement that she didn't really intend to transfer it, why is it unreasonable for us to defer to the credibility determinations of the trial judge made after having a trial and hearing both of the witnesses testify?
So our
If
position...
you don't have any evidence to support your claim anyway.
So our position is that the trial judge did not make a credibility determination. Rather, he said it belies logic. And he found that it belied logic that she would turn over $1 million in an account to the respondent so that he could manage it for her. That finding was directly contrary to the evidence in the case, which is that she wanted nothing to do with him. The
Right, but
parties
the
had-
evidence, the only evidence in the case, other than what they each say, is that she signed a document, as my colleague noted, transferring the
So-
funds. There's no other evidence other than they're both contradictory statements as to what their intent was.
Our position is that the transfer document is dispositive as to the reality that it was not a gift, and therefore it was never intended to become his property. Again, I would point out that this is a person convicted
The
of...
selection of it not being a gift is probably a tax issue versus anything else, because that was within the Vanguard checklist, correct?
It was, and again, our position is that that document is dispositive in this case.
Yeah, it's dispositive of it being transferred and it not being a gift, but it's not dispositive of anything else other than that.
So again, a couple other things that we would...
Does that negate the argument that is being made by the defendant that the money was his all along?
Your Honor, we would point out that it wasn't his all along.
That's what you
We would
point
also
out.
we would also point out that the judge, specifically as to Mr. Kappa's credibility, he said, among other things, his statements were conclusory, unsubstantiated,
But the judge also
inconsistent,
pointed out,
uncorroborated.
counsel, I'm sorry to interrupt you, the judge pointed out credibility issues with regard to both parties. So why can't we defer to the judge who was present and witnessing each party as they testified? Why can't we defer to that determination?
Because although he said that neither party was entirely credible and testimony was not substantiated, the only party whose credibility he directly attacked several times was Mr. Kappa's. With respect to...
But counsel, what does neither party being credible mean? Doesn't that mean exactly what the words say?
And who had the burden of proof?
We had the burden of proof, Your Honor.
Okay, so he finds that neither party is entirely credible. He finds that there was a voluntary transfer, and he finds that based on that, there's no conversion. That you failed to prove that there was a conversion.
So I'd just like to point out, I realize I have 2 minutes left or less.
No, you have no time left. I'm just letting you answer his question. Your time's up.
May I just...
You may quickly answer his question.
The record at pages 1680 through 1886 demonstrate that Ms. Hart deposited a total of over $1 million. There's copies of those checks. You can verify that. In comparison, Mr. Kappa deposited less than $400,000.
Thank you very much.
Thank you.
Go ahead.
If it please the court, my name is Mary Margaret Luby of Gravanti and Luby, and I'm here on behalf of the defendant respondent, Tommy Kappa, and I thank the court for permitting me to appear and virtually argue this appeal. Pretty much the questions that were directed of counsel are items that I raised in my respondent's brief. I believe that the court correctly found that the plaintiff failed to prove her prima facie case of conversion, and I don't believe that anything that the plaintiff put forth in their brief arguing to have the court's decision with
What
respect to the
relevance-
fourth cause of
what rel-
action
counsel,
overturned.
What relevance should we give to who put the deposits into the account over time? What impact should that information have on the result?
Your Honor, I don't believe it should have any, because both of the parties, the initial account, and the record is rift with both parties saying, well, this money was mine, that money was mine, I put in this money. But the one thing, Your Honor, that plaintiff pointed out, Ms. Hart put $1 million into the account, and there was testimony in connection with what that million was. However, plaintiff in his brief and his argument, he fails to address that Ms. Hart, before she even transferred and took her name off of the account, that she admitted Mr. Kappa had asked 3 or 4 times after they'd broken up to take her name off the account. She had already, as of 2007, had already taken out over $880,000 of monies from that account. So when the fact that she may have put money from an account in her, from her checking, it doesn't matter. It was in a joint account. And if the court looks at it, there's so many things that really break her credibility that the trial judge saw in connection with how she brought the first, the conversion claim for Vanguard. Her initial complaint that she filed, she didn't allege any conversion of a Vanguard complaint. She didn't mention anything at all. As soon as Mr. Kappa filed counterclaims, she filed an amended complaint, added a conversion claim. In her complaint, she alleges, oh, well, it was a retirement account. It was for our retirement. He was supposed to manage. Number one, it wasn't a retirement account. It was never a retirement account. And number two, there was no evidence of anything in connection with managing it, because it was self-managed, and she admitted during the trial that she never spoke to him about the account. He managed it, and he was able to do so. So why take your name off of an account so he can manage it if he was managing it all along when she was jointly on the account? It makes no sense. And that's why I think the judge said it belies logic, because all of the reasoning for her, which I believe she manufactured a basis for her taking her name off, it belied logic. It just didn't make any sense. And I think that's why the judge properly determined that her basis for removing her name was just a hoax, and that's why her cause of action failed.
Thank you very much.
Thank you.
You have some rebuttal time.
Your Honor, just one issue on rebuttal, which is it doesn't matter when the claim for conversion was raised, whether the initial complaint or an amended complaint, or quite frankly, after trial, based on the law of this state.
Oh, but
Thank
the
you.
question is whether or not you met your burden on it, and that's what we're troubled. That's the question we've been raising.
So we had the burden, no question about that. I heard Ms. Luby to say that one of the reasons why the conversion claim was problematic is it wasn't raised in the initial complaint.
Thank you very much.
Thank you.
The next case is 163 West 48th Realty versus Sunflower Natural.
Good afternoon, Your Honors. Charles Bulbul for 163 West 48th Realty LLC. The issue before the court is whether a tenant is liable for post-surrender rent following the default termination of a lease. The tenant surrendered possession of the premises pursuant to a written surrender agreement that expressly stated that it was without prejudice to the landlord's claims against the tenant and the guarantor. Paragraph 18 of the lease states that if the lease is terminated due to a tenant's default, which it was, the rent shall continue to accrue on a monthly basis, set off perhaps against the reletting, but the premises had not been relet.
And the court didn't address paragraph 18 in its decision, correct?
The court did not specifically refer to paragraph 18. The court said there was no provision providing for
Paragraph 18 is the
post-surrender rent.
provision that you're relying upon.
Oh, yes,
Show
that's
your right
correct.
to liquidated damages.
Our submission to the court at the time, in September of 2023, recited these facts and provided a detailed calculation of the rent due between January 2023 and September 2023 when the submission was made. The court below held that tenant surrendering possession vitiated the obligation to pay post-surrender rent. The decision of the court below denied post-surrender rent on the grounds that the acceptance of tenant surrender ended the obligation to pay rent, which is contrary to both the facts and the law.
Thank you. Any questions? Thank you very much.
Thank you, Your Honor.
The next case is Zurich American Insurance versus Altera American Insurance.
Thank you, Your Honors. Adam Smith on behalf of Appellant Zurich American Insurance Company, and may it please the court. Altera's argument that it does not owe coverage for the claimant issue here rises and falls based upon one particular issue, that Fine Line, the entity from whom Altera's insured Barocco retained certain laborers, was a quote-unquote subcontractor at the project.
Counsel, why shouldn't we follow the definition articulated by the Court of Appeals in interpreting the lien law? Why wouldn't that be the natural definition we would look to in deciding that question? And if we look to that definition, you look to whether they provided services, which clearly Fine Line did provide services. So why isn't that dispositive in terms of your argument?
Well, respectfully, Your Honor, I'd suggest even under the definition provided by the lien law, they still don't qualify as a subcontractor. And
Is it unquestionable they provided services
they
as
provided,
opposed to material?
well, they provided, certainly, providing labor is providing services as opposed to a material man who provides supplies to a project. But the lien law that you're referring to has definitions for a subcontractor. It has definitions for a laborer.
And
it has-
why doesn't Fine Line fall under the subcontractor definition?
Because there was no contract.
Right,
Responsibility,
but the contract has nothing to do, counsel, a contract has nothing to do with whether someone has agreed to perform services. It has to do with the endorsement clause, clearly, because that's what the endorsement clause falls or doesn't fall on, but it has nothing to do, whatever you agree or don't agree to do, someone else has nothing to do with whether there's a written contract. It seems like a pretty bright line test. Are you supplying services or are you supplying materials?
well, it's more than just simply providing services. The definition of a subcontractor under the lien law is the subcontractor is a person who enters into a contract with another contractor for the improvement of real property.
But counsel,
That
what I'm baffled by is that you said in your brief, and you seem to be saying it now, that there was no contract between Barocco and Fine Line. But when you say that in your brief, you then go on to explain essentially the terms of the agreement between Barocco and Fine Line. So there appears to, are you claiming that there was no oral contract between them?
there's no written contract.
I know there's
We're
no
not
written,
aware.
there's no, I agree that there's no written contract. We all agree there's no written contract. Are you claiming that there was no oral contract?
There's nothing in the record establishing what that, I don't know one way or another whether
Well,
I-
except in your
they
brief,
provided-
you set out essentially what the terms of the contract are, that Fine Line will do certain work and Barocco will pay them certain amounts of money.
I think our brief refers to the contract between R.C. Dolner, the general contractor, and Barocco as the subcontractor, not the other way around. But what I was
Is
trying
there
to get
any
to, Your Honor,
dispute in this case that Fine Line agreed to perform services for Barocco?
there's no dispute that they
So-
agreed to
so-
provide laborers. No,
So
I
if they
agree.
agreed to provide laborers, and they obviously agreed to be compensated for that, that's undisputed, why
Sure.
isn't that an agreement to provide services?
Because they didn't assume any portion of the contract that Barocco had taken on, their scope of work that they took on from R.C.
How could that
Dolner.
be? Because wasn't Barocco's job to provide services, to do the work? And the only way it could do the work is by having people to do the work.
Well,
So
Barocco
it's a-
had people to do the work.
Right,
Your
but it
Honor.
obviously got more people from Fine Line to do the work, to help it do the work. So how could that not be performing, I'm not sure I'm following your argument.
Well, the A.J. Byers case, a Second Department decision that addressed the New York lien law is a perfect example, and it's a case relied upon by Altera. In that case, they were talking about whether a material man, as opposed to a laborer, was a subcontractor, and they found that he was not. And they said the reason it was not was because they didn't assume any response. For example,
Because they were just supplying, the
Materials and-
distinction between supplying materials and supplying labor is not, are you arguing supplying labor, supplying materials?
I'm sorry, Your Honor, I couldn't.
Are you arguing that supplying labor is supplying materials?
No, but it's another distinction. If you follow the line of logic that Altera is utilizing, there's no, any time you provide labor to a project, you must be a subcontractor. The lien law makes a distinction between laborers and subcontractors. It's in the definition section. There's no distinction here. The responsibility for the work, had they Barocco took on the excavation, the demolition, and the rebuilding of a sidewalk and a construction project here in Manhattan. Fine Line had no responsibility for demolition. Fine Line had no responsibility to design it, pour concrete. They worked solely under the control and responsibility of
Right, but they
Barocco.
supplied, you only have less than 2 minutes left. Do you want to address the horizontal exclusion rule at all in the Scottsdale decision and how that applies in this case, or do you want to spend your whole time?
I
on
prefer to spend my time on this. The short answer to that question on priority of coverage, Your Honor, is R.C. Dolner has a contractual indemnity claim against Barocco that, if successful, results in
Right, but
vertical
though,
exhaustion. That's-
it seems like the distinction those cases make is between when you've actually gotten liability on your indemnity case, like when there's actually been a determination that the pass-through is definitely occurring, versus when you just have a potential claim that might occur.
That's fair, Your Honor. We don't disagree, but we want to make the point, that claim is still out there. pending.
Right, so how can you take advantage of the exception when there's been no determination yet that there is any contractual indemnity?
Well,
That's what I guess I want to know.
There's a distinction, Your Honor, and again, not to belabor the point, they're relying upon coverage for R.C. Dolner. If we're talking about coverage for R.C. Dolner, we acknowledge that it's horizontal allocation, horizontal exhaustion. However, when you're talking about coverage for Barocco, and that's where the contractual indemnity claim comes into play, the case law is clear that the contractual indemnity claim would trump it. But I appreciate
Right, but you haven't been successful on a contractual
it has
indemnity.
not been resolved yet.
Right, so in the cases where they've allowed parties to bypass the horizontal exclusion rule, they've allowed it because there's actually been a determination made that there is contractual indemnity where no such determination has yet been made in this.
I can't dispute that, Your Honor. If there are no further questions, I'll save my rest of my time for rebuttal.
Okay, thank you.
Good afternoon, Your Honors. May it please the court, Matthew Falazza with Hinshaw and Culbertson, here on behalf of Altera, who issued the excess policy to Barocco. I think the court has hit the issue right on the head.
Counsel, how do you deal with the argument by your adversary that because all of the Fine Line employees were supervised by Barocco and worked under the direction of Barocco, that they were not quintessential subcontractor in the sense that Barocco controlled the laborers?
I think, Your Honor, The subcontractor is someone who assumes performing part of the work. In this case, Barocco had to provide all of the labor according to their contract.
I guess a part of his argument, and I don't mean to interrupt you, is that perhaps they didn't assume a part of the work because Barocco still maintained control over the laborers from Fine Line.
But by even providing the laborers, they're assuming part of that work because Barocco's obligation was to provide all of the labor, and they couldn't, and they had to bring in Fine Line to provide some of that labor. So therefore, under that situation, Fine Line is assuming part of Barocco's obligation, which is to provide some of that labor.
And what about the argument that there's no contract, that Fine Line had no contract?
There's no written contract, Your Honor, but there had to have been at least an oral contract because we know Fine Line provided the laborers. Without some sort of agreement between the two companies, there wouldn't have been the provision of the laborers. So there doesn't have to be the written contract, but there must be at least an oral contract here. Otherwise, Fine Line would not have been providing those laborers. Just also to, unless the court has other questions on the subcontractor issue, addressing the exhaustion and priority of coverage issues, again, I think the court did hit the issue on the head there, which is there's a distinction between a situation where there's a contractual indemnity finding, which there has not been.
Counsel, what about the fact that the only reason it was denied was not on the merits, but on a procedural basis, and that it wasn't a timely made, the motion for summary judgment? Is there any real issue as to whether there should be contractual indemnification here?
We don't know all the facts of the underlying, Your Honor, whether there should have been or not. That question was left open on a procedural issue.
No one ever moved forward on that question in any way?
Now the case is marked as far as we know, disposed. You know, we understand there's a settlement. We don't know all the terms of that settlement. It hasn't been put before this court, so we can't, you know, put those terms in front of the court. So as it stands right now, that question remains open.
Okay.
Unless the court has other questions, we'll rest on our briefs.
Thank you.
Very briefly, Your Honors, and to address the question that was posed to counsel, Fine Line did not assume responsibility for any portion of Barocco's works. They accepted direction from Barocco. The workers were told what to do. Barocco has testified, it's in the record, that they had sole responsibility for
Why is
when they
that
called the labor.
inconsistent with there being a subcontractor? Isn't that often what a subcontractor does, is to follow the directions of the depending on what the contract, either written or oral, says as between the contractor and sub, the sub may simply follow directions of the contractor but provide labor to do so.
Actually, Your Honor, subcontractors almost, and if you look at the Gemini case we provided the court, and in most of the cases they refer to subcontractor, would control the means and methods of the work they perform. Barocco Fine Line had no control over the means and methods here. That was Barocco who had total control of the means, the methods. If they wanted the laborers to go get them coffee, that was their responsibility. They could tell them to go get coffee. So they were not a subcontractor under any definition that's been provided to this court, unless the court, I see my time's up, unless the court has further questions, we'll rest on our papers. Thank you very much.
Thank you. People versus Conyers.
May it please the court. For Mr. Conyers, Sarah Siegel. Objection was futile in the trial court because People v. Hughes, a case with remarkably similar facts, decided the same constitutional question about the same statute at issue here. Under People v. Cabrera, that high court decision was enough to render objection futile and to jettison the preservation requirement.
So don't we have many cases from the First Department finding that a defendant such as this does not have standing to assert these claims?
No, Your Honor.
You don't have many cases saying that?
Not this claim, Your Honor. The standing cases involve matters where the statute was different and the basis for disarmament was different. Namely, the challenges in those matters related to the general proper cause standard that the Supreme Court invalidated in Bruin itself. This is different. It is different because the statutory scheme itself in New York.
He applied for a license, though?
He need not, even under.
Isn't that the basis of all of our decisions, that the reason these defendants don't have standing because they never applied for a license? So isn't that the same in this case as in all the other cases?
It's different in this case, Your Honor. The reason is that all of this court's cases regarding standing rely on the Second Circuit's decision in De Castro, which specifically says that where the defendant appellant can make a substantial showing of futility with respect to an application for a gun license, that doesn't, the failure to apply for a license is, has
I
nothing
don't
to do
remember
with
that
standing.
analysis being in any of our decisions, the futility argument. I recall all of that, our decisions saying, because you never did apply for one, you don't have standing, but.
And it was specifically in those cases where the statute itself did not bar the appellant's licensure. But here, the statutory scheme itself barred Mr. Conyers from obtaining a license on the same basis that the statute of conviction punishes him, namely his prior conviction, which is, as the court is aware, the basis on which we challenge the constitutionality of the statutory scheme. Under De Castro, which is the basis for all of the court's opinions, De Castro required an application for standing purposes in the civil context where there was some question in the record whether the appellant would have been eligible or not. Here, there's no question because New York statute plainly barred my client under Penal Law 400.00 sub 1 sub C from obtaining a license on the basis of his prior nonviolent convictions. We know
There's
that
nothing about Bruin that has held that unconstitutional, that has said that New York cannot regulate its licensing statute.
what Bruin does, Your Honor, is it sets out a historical test that is fatal to the conviction here. It does that, and I do want to address any preservation or other procedural problems that may arise, but to turn to the merits, Your Honor, Bruin specifically requires that the state, the burden is on the state, come up with a historical analog that is comparable both with respect to the burden imposed, the punishment imposed, as well as the justification imposed. That historical analog must be widespread across many states, must not be otherwise unconstitutional, and must have existed during the relevant time period, which is certainly the founding, may also include the time around 1868, and does not include.
Did Bruin invalidate the other provisions of the New York's licensing statute?
Its holding does not. Its rationale does. Or at least its rationale does invalidate the prior conviction bar.
So the holding doesn't, but the rationale does.
Yes, and that is entitled to precedential weight under Supreme.
Is there any decision in this court where these claims have been brought to the First Department that the court has held that?
As far as I know, this is a question of first impression in this court, Your Honor. I do want to speak briefly about the merits, if I may. Justice Barrett.
Preserve the claims below? Before we get to the merits?
Under the Court of Appeals decision in People versus Cabrera, specifically regarding Bruin preservation claims, preservation is not required here because trial court objection would have been futile under People versus Hughes. People versus Hughes is a high court, Court of Appeals case. People versus Cabrera specifically held that intermediate appellate court precedents that are adverse are not enough to render objection futile, but it also specifically held that high court decisions are enough. And there is one specifically regarding this statute and a Second Amendment claim. That's People versus Hughes from 2013. That was not the case in People versus Cabrera. This is really quite different from People versus Cabrera. It is the natural follow-on. In People versus Hughes, which is remarkably similar on its facts, involving someone who was prosecuted under this statute for possessing a gun in the home he lately had shared with a romantic partner, Mr. Hughes challenged his punishment, the burden the law imposed, on Second Amendment grounds. In other words, he made a Bruin argument before Bruin saying that his prior conviction, in that case resisting arrest, did not justify imposing the punishment that this statute did on him. And the Court of Appeals in People versus Hughes said, too bad, so sad, you lose. Under that precedent involving the same statute, remarkably similar facts, and precisely the questions that Bruin now requires us to analyze differently, to wit, whether the burden this statute imposes is justified under the Second Amendment. That is the whole Bruin question. That is, quote, the central question under Bruin. When people versus...
Thank you.
Thank
I'll let you finish up on rebuttal.
Thank you.
Good afternoon, Your Honors, and may it please the Court. Connor Burns for the people. Defendant did fail to preserve the challenges that they do raise now below because they did not raise any of the constitutional challenge before the trial court. And certainly, the lack of preservation shouldn't be excused here because it wasn't futile. Hughes dealt with, yes, there were certainly similar facts and dealt with the same statute, but the argument in Hughes, the argument that defendant raised was different than the ones that defendant raises here. There, it solely decided whether or not it was unconstitutionally severe to punish the defendant for at-home possession of a firearm as a C felony. Here, and it didn't deal with the issues that defendant raises, which is whether defendant's prior conviction was an appropriate avenue to extend or expose him to further more severe punishments under the weapons possession statutes. And then just regardless, even if this court does find that Hughes foreclosed defendant's arguments, this court in People v. Adames found that a futility exception does not apply to unpreserved Bruin claims because a defendant, as the court said in Adames, should not be allowed to avoid the consequences of a lack of preservation by arguing that those claims are futile.
Counsel, to be clear, though, Bruin only invalidated the proper clause section of proper cause section of the statutory scheme, correct?
Correct, Your Honor, yes.
And it didn't invalidate any other sections of New York's licensing scheme, correct?
Correct, yes. The only section that was addressed and invalidated.
What about your colleague's argument that the rationale in Bruin invalidated the other sections of New York's licensing scheme?
I think even the opposite. I think Bruin, again, certainly only addressed the proper clause requirement, but in Bruin, the decision itself mentioned that Bruin and other Second Amendment cases shouldn't be seen to cast doubt on the longstanding prohibitions on bars of felons possessing firearms. So certainly, I don't think the rationale called into question or would question the constitutionality of the New York's licensing regime, which would bar those who have prior felony convictions from possessing firearms.
You want to address the standing issue, whether or not this defendant has standing?
As the panel has noted, defendant, and as counsel doesn't dispute, defendant didn't apply for a license in this case, and that would certainly...
Is this case different, though, because he wouldn't have gotten it even if he did apply for it?
Well, there's no way of knowing that. There's certainly other than the challenge provision of the New York licensing regime, that there's other restrictions to licensing that could have applied here, but we just don't know if those would have applied because defendant didn't submit to the licensing regime, didn't undergo a background check, which would have potentially revealed other restrictions.
Well, it's uncontroverted that he had a previous felony, right?
Correct. His previous felony.
And as having a previous felony, he would not have been able to obtain a license, correct, under the statutory scheme.
Correct. That certainly was one avenue, but again, because he did not submit to the licensing, because he didn't submit for a license, there's no way of telling whether he would have been barred under one of the other licensing restrictions that are constitutional that the defendant does not challenge on appeal here. So that is the distinction here, and that's why his failure to apply for a license is fatal and means that he would not have standing to challenge the licensing regime on appeal now. Just briefly on the merits, again, as the panel, Justice Michael noted, Bruin did not invalidate the licensing regime, the portion of the licensing regime that they do now challenge, and then there is historical precedent for banning felons from possessing firearms. And then just finally on the prior crime exception under the penal law statute, the weapons possession statutes that they also challenge. These do not fall under the Bruin historical analysis purview because they don't regulate conduct. The second degree and third degree weapons possession statutes, which do take into account prior convictions, only work to enhance a defendant's severity of punishment as opposed to regulating conduct on themselves. And if the court has no questions, we ask that you affirm.
Counsel, Is there any case where someone had standing when they did not apply for a gun license?
Yes and no. First, I would point the court to an extensive discussion in our reply briefing, which discusses a recent set of concurrences by Justices Alito, Gorsuch, and Thomas. In that case, Wilson versus Hawaii, Hawaii's High Court had a remarkably similar requirement to the one that the prosecution advances here, saying that one could not use the Second Amendment as a defense unless one had applied for a gun license in the first instance on standing grounds. The Supreme Court found that an essentially interlocutory appeal was not yet ripe for full review, but those three justices I mentioned wrote separately to encourage the appellant to reapply or someone else to reapply because they found that that standing argument, that standing holding was unconstitutional on due process grounds. And so the writing is...
How is that a yes to the question, though?
I do think that the opinion of three justices of the Supreme Court is relevant to this court's determination, Your Honor. With respect to the standing argument in particular, I do just want to remind the court that this court's previous opinions on the standing matter do not deal with an instance where it is conceded that an application would have been futile. I do want to turn briefly to the question of...
No, your time's up. Thank you very much. Thank you.
Thank you.
People versus Hines.
May I begin?
Oh, sure.
Yeah. Clara Hammond-Oakley on behalf of Appellant Princeton Hines. Your Honors, I would like to begin by addressing the appeal waiver in this case and then talk about the search warrant. The way that the appeal waiver was added on as a condition of this plea in this case was extremely unusual. What happened is that Mr. Hines appeared in court in February and he was made an offer by the court. That did not include an appeal waiver. He actually started accepting that offer and then pleading guilty, and then in the middle said that he needed more time to consider the conditions. The court adjourned the case for a month for Mr. Hines to consider those conditions.
Which is something we want courts to do, right?
Yes, certainly.
Okay.
And it was certainly necessary.
So what was wrong with that?
There was absolutely nothing wrong with that. And it was necessary in this case because Mr. Hines was a 23-year-old who had never pled guilty to a crime before. This was a very serious plea. It had complicated conditions. And
then
additionally,
you come back to court and the people decide that if he's going to accept the plea, that they would like that to be their offer and that there should be a waiver of right to appeal attached to the offer.
Yes.
What's wrong with that?
Because then suddenly on the record, Mr. Hines is told there's going to be an appeal waiver. The only explanation of it that was provided to him before he actually admitted factual guilt in court occurred off the record while him and his lawyer were standing there.
And the court also inquired to ensure that Mr. Hines understood the waiver, right?
After Mr. Hines had gone through all the Boykin rights, after he had admitted in court to attempted murder and to possession of a gun, it was then that the court explained the appeal waiver to him.
And there's nothing wrong with that as per this department's case law, right?
There's nothing wrong with that under a usual circumstance. However, this record contains much more information about Mr. Hines and about what Mr. Hines needed in order to understand the conditions attached to his plea. This was a first-time offender. He was young. He was diagnosed with ADHD, special education student, did not graduate from high school. He made it clear to the court that he needed time to consider these conditions, and he did simply not have time to consider the appeal waiver before he agreed to it.
Record, given that he did have an opportunity to discuss the waiver of right to appeal with his lawyer before the proceedings started, and that the court went over it with him, is there anything in the record to suggest that he didn't understand it?
Well, when the court asked him during that appeal waiver colloquy, again at the very end, whether he had discussed it with his lawyer, he actually said no. So clearly he did not feel that the explanation that he had received at the outset of that plea was sufficient for him to really understand the important rights that he was giving up. This court enforces appeal waivers because they're part of a carefully orchestrated bargain between the prosecution and the defendant. Mr. Hines had a carefully orchestrated bargain. It was one that he thought about for a month, and he came back after a month and decided to accept it. That is what this court should
disagree with
enforce.
you regarding the waiver, and we find that the waiver was valid and that he understood it. What import does that have on the rest of your argument?
It would mean that this court would not be able to consider his excessive sentence argument, and it would also make it much more difficult for this court to consider his very meritorious search warrant issue here.
What would the basis be for the court addressing the search warrant if he waived his right to appeal?
Perhaps this court could decide that because the oral colloquy did not specifically say that Mr. Hines was waiving that right and instead only referred to the excessive sentence argument.
But if we find that the waiver is a valid waiver, then there's no basis for us to address the search warrant issue.
I agree, Your Honor.
Okay, I just wanted to make sure you didn't have another theory out.
Now, if we find that the waiver is not valid,
Yes,
then we address the warrant issue.
yes.
And so, what was in the warrant issue that would cause this court to somehow reverse what was done in Supreme Court?
Because this warrant there was no probable cause to believe that evidence of the crime would be contained in Mr. Hines's Instagram account. The only case-specific allegations in this warrant affirmation were reasonable cause to believe that Mr. Hines had committed a crime and reason to believe that he had an Instagram. There was nothing connecting those.
What was found in his Instagram account that would prejudice Mr. Hines?
We don't know. They received things from Instagram. However, it's not part of this appellate record what was received. There could have been extremely exculpatory information, inculpatory. We simply don't know.
But do we know for a fact what the police officer viewed prior to requesting the warrant? And by this, I'm referring to the things that occurred in the commission of this offense, meaning the surveillance video that saw him shooting at the individuals that were injured and saw him with a gun, and the fact that he was apprehended at the location and that the gun was there with him.
The gun was not actually there with him. No gun was ever recovered in this case, despite the fact that Mr. Hines was arrested, I believe, minutes after the shooting occurred on video. I believe that this court's, when reviewing the sufficiency of a search warrant, is limited to what the deponent officer puts in the search warrant application.
So, counsel, what the deponent officer put in was simply that the Instagram page was public. He viewed it, and he saw that the person on the page was Mr. Hines.
Yes. Yes, but there's no link there to the crime itself. There's no allegation that the complainant had an Instagram page, that they were friends with each other on Instagram, that Mr. Hines had posted sort of arguably criminal content publicly on Instagram, which would lead one to reasonably infer that he was doing other things in private messages. There wasn't even an allegation that Mr. Hines didn't have other social media accounts, that, you know, even if it was true that people who commit assaults tend to post about them on social media, that he wasn't posting it on Snapchat or Facebook or something else other than Instagram.
Thank you.
Good afternoon, Your Honors. May it please the court, Jennifer Mitchell for the people. To begin with defendant's valid waiver of appeal, I want to be clear that this was not a plea to the indictment, so no matter what the offer was, the people had to consent to whatever the court had offered defendant at that February hearing. And so it was well within the people's right to require a waiver of defendant's right to appeal as part of their consent to that plea offer.
Counsel, your adversary indicated that Mr. Hines answered no to whether, in fact, his lawyer had gone over the appeal waiver with him, and that somehow that is evidence that he didn't understand. How do you respond to that?
Your Honor, there is simply nothing in the record to support that. Even if at one point he had answered no, which I don't believe that is true, but for argument's sake, if it is, the court then provided him with the opportunity to speak to his attorney and that's shown within the proceeding. And so defendant then had the opportunity to talk to counsel, and the court only continued to move on after he confirmed that they had spoken.
So what he said was, what the court said was, have you spoken about this issue with your lawyer? Defendant said no. The court said, speak to him now. And then he responded, yeah, which means he clarified that he then understood that he had spoken to him already.
Exactly, Your Honor. So that shows that he had then taken the time to speak with his attorney regarding this entire plea offer, which again included the valid waiver of appeal that was part of the people's condition of their offer.
Let's move on to the search warrant issue. What was the nexus between what the deponent officer testified to regarding the search warrant and some reasonable belief that evidence of criminality would be found on this social media page?
So, Your Honor, the police officer put in the affidavit that he had viewed surveillance footage that showed the defendant chasing after the victim, pointing a loaded gun at him, and firing numerous shots.
That's a surveillance video. That was not posted on his Instagram page.
Correct, Your Honor. From there, he was informed, in the course of his investigation of this crime, he was informed about defendant's Instagram account. And when he viewed the public posts that are available to anyone in the public to see, he saw pictures of defendant confirming that this account did indeed belong to defendant.
Okay.
And in the affidavit, the officer stated that in his experience investigating homicides, assaults, and weapon possession charges, it was likely to find evidence of those type of crimes on a defendant's social media account.
A defendant, nothing with regard to Mr. Hines in particular, right?
Well, so in this particular case, we can reasonably infer that he thought he would find evidence about the motive and intent of this crime.
Are we able to reasonably infer in order to find probable cause to grant a search warrant?
Yes, Your Honor.
Without a specific nexus?
I do believe we have the specific nexus here, Your Honor, in addition to the reasonable inferences we're able to draw, because the officer said, one second, Your Honor, excuse me.
Okay, putting that aside, right, even if we said that the search warrant was improper, would you say that that was harmless error in regard to the other evidence in this case?
Your Honor, I would shy away from using that specific language just because of the guilty plea in this case, and I know there's some question about whether you can have a harmless error argument with a guilty plea versus a trial. But the point remains, Your Honor, that regardless of whether or not this warrant was valid, this was found, this crime was caught on surveillance video, and nothing, we don't know what, if anything, was discovered based off the search warrant of his Instagram that prejudiced him in this case. And so,
so that's really the key, right? The fact
Yes.
that we don't know that there was any information found from the search warrant that was prejudicial in any way to Mr. Hines.
correct, Your Honor, exactly. And on that note, I would just...
Counsel, may I-
Yes, Your Honor.
with regard to the nexus issue raised by my colleague, if you're saying that the nexus essentially is the officer's view that based on his experience, he might find something useful on the Instagram account, wouldn't that justify a warrant for an Instagram account for anybody who's a criminal defendant?
No, Your Honor, that's not at all what we're saying. But here specifically, it was appropriate because, again,
What's specific to this case? That's what I'm having trouble with.
based on the surveillance video, we can infer that this was a targeted shooting because the surveillance video showed this defendant.
How does that lead you to the Instagram account?
Again, the officer was informed by an informant in the course of the investigation about defendant's Instagram account.
But all that he learned from the confidential informant was that defendant had an Instagram account. There was nothing, there's no evidence that the confidential informant said that the defendant's practice was to post evidence of his crimes on his Instagram account.
Correct, Your Honor, but again, in this police officer's experience, it's likely to find such evidence on the social media accounts. And since he was specifically directed to his Instagram account in this case, that is the place he decided to search. And again, from the surveillance video, we can infer that
The account was public though, right? So he was actually looking for non-public things like direct messages.
Exactly, Your Honor. Yes. So he was able to view the public part of the profile, which was the photos and such. But they obtained the search warrant to search through the messages in hopes of finding some evidence of his intent and motive behind this shooting. Again, because we can infer that it was a targeted shooting, it was reasonable to believe that evidence of the defendant's connection with the victim would be found on his Instagram account.
Thank you.
Thank you.
So, Your Honors, the people say that the judge would never have been allowed to offer or give Mr. Hines a plea that did not include an appeal waiver without their consent. Regardless of the merits of that, what we're looking at here is Mr. Hines's perspective, what Mr. Hines understood. Did he have an understanding of the important right to appeal and the consequences of its waiver? From his perspective, this was a court offer that did not include an appeal waiver, and that was made very clear on the record multiple times by the court. And from his perspective, he only learned that an appeal waiver was going to be added right before he started pleading guilty, after he had thought about the prior offer for a whole month.
Finding it out right before doesn't change the fact of it being explained to him and whether, in fact, he understood what was explained to him. And there's nothing in the record to suggest that he didn't.
It affects whether or not this court can be certain that he understood it, given his background, given the fact that he needed that month to consider it.
Thank you.
Thank you.
Cusimano versus Super P57.
It please the court, Daniel Cerritos from the firm of Cullen and Dyckman. Your Honors, quite simply, we have a steel beam that is stationary and
Let's
stable.
not just say steel beam, right? It weighed 1,000 pounds, right?
Correct. It weighed 1,000
And
pounds.
it fell on the plaintiff's leg.
Correct. And nevertheless, it was still not moving. It was stationary, and it was balanced and stable on the dolly that was designed for the express purpose of transporting steel beams such as this 1,000-pound steel.
But it felt right.
And it did fall, but it wouldn't have fallen but for the actions of the plaintiffs.
Would it have fallen if it had been properly secured?
Yes, it would have still fallen. The argument is that the beam clamps or the straps in contention that were used at the time would have prevented this from happening, but that's not the case.
What evidence in the record supports that it would not have fallen that it would have fallen even if the clamps were placed on it?
Well, we have the testimony of the plaintiff's supervisor, who was the superintendent, John McGuire, who said that the straps and clamps are strictly used just for transportation because they only stabilize the beam. They don't prevent it from tipping over. Additionally,
Did the supervisor say that had the clamps been placed on it, that this beam wouldn't have fallen in the position where it was?
no. What he was saying is that the clamps and the straps are only used for transportation. And once it's brought to the location where it's going to be installed and set, the clamps and any straps that were on it would be removed because, one, the weight of the beam would hold it in place, and a significant force would be required to knock it off its base. Two,
If that's true, what was the significant force here? I mean, that was so significant that it would knock it off. I mean, I know he was working on it, but that doesn't sound like a significant force.
well, here, the expert, Mr. Abram, indicated that 84 pounds of force needed to be applied on the beam. Here, what actually happened was, by admission, the plaintiff himself attempted to push the beam, which he had instructed his own workers that was unsafe. The beam can't be moved safely by one person, given the size and the
What
weight.
evidence do we have that the plaintiff attempted to push the beam and that push equated to 84? What did you say it needed to be from?
84 pounds of pressure on the
84
beam.
pounds of pressure?
Correct. That's what the engineer expert who was
Using some sort of mathematical formula.
Correct.
That he explained in his
in his affidavit, correct. So basically, Mr. Abram indicated he reported to the site immediately after the accident. He measured the beam, both length, height, determined its weight.
Right, but what evidence do we have in the record that the plaintiff applied 84 pounds of pressure to the beam that caused it to fall?
Well, what we have is an admission twice by the plaintiff. First, he told the responding EMT, who transported him from the accident site to the hospital, that the accident occurred when he pushed the beam, and the beam fell onto him. Second, while at the hospital, he testified, or he told his supervisor, John McGuire, that the beam fell when he pushed it. So we have twice, by two separate independent witnesses.
Counsel, is there any clear opinion in the record that if the clamps, even if the clamps had been attached, it would not have fallen under the factual circumstances of this case?
Yes, Mr. Ibram specifically said that based on his calculations, a casual brush-up, such as the plaintiff testified that could have happened, wouldn't have caused the beam to fall.
But does he talk specifically about if the clamps had been attached under these circumstances, it would not have affected one way or another, whether or not the fall would have?
Yes, he did. In fact, he also did his calculations and said if the clamp or a strap was on the beam, 130 pounds of force would need to be applied on the beam, and that was consistent with an individual pushing the beam, which is what the plaintiff admitted to doing.
What about the fact that the plaintiff stated that the beam shifted, or the dolly shifted when he stepped on the plywood, causing the beam, because it was not properly secured, to come off the dolly and strike him?
Well, Mr. Ibram, again, also calculated the force of any deflection on the wooden platform. So he indicated that even calculating the weight of the dolly, the steel beam, and the plaintiff all on the same piece of plywood, that would not have generated sufficient deflection in the plywood to cause the beam to tip over.
We're talking now about the force of gravity, right? Because if the plywood shifts and we have a heavy object on top of it that is sort of like leaning or tipping, that could cause that heavy object to continue to slide and fall on somebody, wouldn't it?
Right, and Mr. Ibram calculated that it would take between 2 to 3 inches of deflection of the wood in order to cause the beam to tip over. And in this case, we don't even approach that.
Why not? How does he know how far that wood shifted?
Well, Mr. Ibram went to the location. He measured and evaluated the wood platform upon which the steel beam was on. And based on physics and his measurements, he was able to calculate how much force would be put onto each plank and how much deflection, which would be the actual dipping that you're referring to, would be caused by the weight of the beam by itself, as well as how much deflection would be added if the plaintiff stepped on the middle of the plank, or he also calculated how much force and deflection would be caused by him stepping near the wheel, where a portion of the weight of the beam would be put on the wood. And none of that was sufficient to reach 2 to 3 inches of deflection that would be required to tip over the beam.
Thank you. You have time to rebuttal.
Thank you, Your Honor.
My name is Scott Singer, and I represent the plaintiff respondent in this act.
You want to address the arguments about the expert's testimony and the
I'd
clamp
like
or
to
lack
address
thereof?
those. I can't wait. Actually, you just have to look at what Mr. Erdem said. It's at 727 of the record. He said, if the beam was not secured with a bridge clamp, the stability of the beam against tipping over could be significantly reduced. He agreed that there was a very strong chance that if this had been properly secured, that nothing that happened would have caused the beam to tip over. But it wasn't secured. He said, yes, he talked about, he gave the numbers, 84 pounds to tip an unsecured beam, but it would have taken 130 to 324 pounds to deflect a...
What about counsel's argument, though, that the act of plaintiff moving it was enough to reach that force?
Well, the plaintiff testified that if he touched it at all, it was an inadvertent, very minor touching.
Wouldn't...
I'm sorry, Your Honor.
I was just going to ask, wouldn't that be comparative negligence, which wouldn't be a defense to 241?
Yes, that would be comparative negligence. Because here it's undisputed there was no clamp securing this. Absolutely undisputed. It was confirmed by the defendant's superintendent.
So even if he was trying to move it by himself, your argument is that that's comparative negligence at best, and it was that and the lack of the clamp together that would have contributed to the accident.
That's correct. Comparative negligence was not the proximate cause. He was certainly not the sole proximate cause, because the fact that the beam was unsecured was a proximate cause of the accident and the primary cause of it.
How do you respond to counsel's argument that the use of a clamp is totally unnecessary once the beam has been moved to where it needs to be and it's only appropriate during transportation?
I would really hope that the court, you probably have already looked at it, but if you look at the picture on page 1194 of the record, you see a 2-foot square dolly supporting a 20-foot long, 1,000-pound beam. This was an accident waiting to happen, and it was not secured, and they didn't comply with their duty under the labor law to secure it. This was a terrible setup. Obviously, it needed to be secured because any slight movement of the beam, anything that perturbed it, whether it was the deflection of the platform or the plaintiff rubbing into it, would have deflected it. This was not arguably a safe condition. It was not, and it needed to be secured. You could see from the way it was set up. And pretty much, whatever Mr. McGuire said, from his company. By the way, it was clear that, Jerry Spallone was asked about what the procedure was, and he said the procedure was very simple. You have the beam secured, and when you're going to rig it to the chain hoist, once it's rigged, you immediately detach it, and then they can lift the load. There's no obstacle to doing that. That's the logical and the safe way of doing it. You wait until the hoist mechanism is actually attached to support it, and then you can undo the clamp. Did I make myself clear? I didn't. Okay. So if there are no further questions, I'll rest on my brief.
Thank you very much.
Thank you, Your Honor.
Counsel, as this being your motion for summary judgment, right, you would have had to have proven as a matter of law that the plaintiff was the sole proximate cause of this accident. How can we find that if there is so much evidence that the clamps would have potentially prevented this accident from happening?
Well, Your Honor, we're appealing both the denial of the defendant's motion for summary judgment as well as the granting of the plaintiff's cross motion for summary judgment. So as to the argument in favor of our motion for summary judgment, the testimony that we have, the expert opinion of Edom, which was unopposed, clearly established that a clamp was not required, nor was it expected. Mr. McGuire and Mr. O'Malley both testified that, in fact, had the beam that was just waiting to be installed had a clamp, it would have created a dangerous condition, because had someone other than the individuals that transported the beam to that location not realized that the clamp was still there, because that's not the norm to keep a clamp on a stationary beam, and they went to rig it up and then lift it, that would have created a greater hazard, because now you have a suspended beam with a dolly that had to be dropped and it could have fallen.
Thank you.
Thank you, Your Honors.
DGC Notes versus Prusi.
Good afternoon, Your Honors. May it please the court, Shari Laskowitz for Appellant Prus. And I would like to introduce Mark Passanante and request that he be permitted to argue the appeal today. Go ahead.
Thank you, Your Honor. I appreciate the courtesy of allowing a visitor to argue this matter. From an appellant standpoint, it's really a matter of whether or not the contract has any ambiguity into it. In this particular case, there's several areas where we believe there's some ambiguity. One of them is whether or not there was a provision of services and what those services were, whether they were tied to employment. The second one is whether or not the definition of a partner, as in becoming a partner, used in the note was completed, and therefore, even if he was terminated as a partner, at the time his employment was terminated, he did not cease to become a partner in the notes.
So does your argument depend on our finding that the non-solicitation and non-competition clauses created an obligation to perform services?
Well, I think those are themselves services. I think it depends on how you define.
That in all my years, I've never heard an argument like that. It's very creative.
Is there any support for that? Is there any case law supporting that?
Well, I think it goes to what the definition of services
Counsel,
is.
that's my
I'm not aware.
question.
I'm
No.
not aware of a case law one way or the other.
Okay.
So,
No one's made this argument before. It's so novel.
well, it depends on what you consider services. And to be honest, Your Honor, there's actually two issues. One of them is
How could
whether or
that
not.
be providing services, counsel? I'm a little mystified
instance,
actually by the argument, because you're not actually doing anything. You're refraining from doing things for your contractual obligations, but you're not actually doing anything for the company. You're refraining from doing things.
Well, that's because you're tying the definition of the word services, which is not tied to employment in the note. They're
Services
independent
means
contracts.
to do. You're of service to someone. You do something for them.
I believe
The
services.
general meaning of services.
It includes a benefit.
Refraining from doing something. It means
I
you're
would
doing
disagree. It includes providing somebody a value or a benefit. For instance, I would just use the attorney-client relationship. We provided a value and a benefit. One of those is that somebody can tell us things that remain confidential.
But if we agree not to work on your case, are we providing a service to you?
Well, sure, and he was employed. He was providing a service, but our duty and the service we provide as far as confidentiality continues beyond the termination of the employment of the lawyer-client relationship. Well, I'm still duty-bound. I'm still providing that particular
So
value.
should the client continue to pay you for those services?
I would think that would be a matter of contract, Your Honor, not a matter of theory. If I've got a contract with them, there's nothing wrong with that, I don't think. But I don't think that's the issue that we have to address here.
But again, would you, is there any support for your claim that a lawyer's continuing to hold a former client's confidence is confidential constituted providing services to that client? I think that's an extraordinary argument. I've never seen anything like it.
It's an
So if you
extraordinary
can tell
argument.
me of
It's-
anything supporting it, I'd be really grateful.
I would be happy to provide a supplement as far as that goes, Your Honor. But
Not
I can
necessary.
tell you, I'm not aware of any case law one way or the other than the general definition of a benefit. You provide something of value and something of benefit. But there's a second argument that's not tied to whether or not the services are related to just the employment services. The note itself identifies an initial term. And it identifies the initial term as there's a start date, December 26th, and unless otherwise terminated, according to Section 7, according to a different section of the employment agreement, 7 years later. Within the definition of initial term includes the shorter term, because it doesn't define the term as 7 years. It defines the term as starting on a particular date and unless terminated earlier, ending on a particular date. So if it terminated earlier, then the initial term is the early termination. And in that case, if you tie services to employment and continue to supply employment services, those terminated on the same day. But the initial term also terminated on September 4th, 2020. That is within the definition of the employment contract. That unless it's terminated early, it's 7 years. Well, if it's terminated early, the initial term is now 3 years. So if you tie services to employment, the initial term ended 3 years instead of 7 years. He was still providing services all the way up until the initial
Another
term ended.
novel argument.
What?
I said another novel argument.
If you look at I'm just reading the contract, Your Honor. It doesn't say the
it's a
initial term
novel
is 7
argument.
years no matter what.
Thank you, counsel. You have time for rebuttal.
Thank you.
Thank you, Your Honors. Ross Pizer on behalf of BGC Notes. As Your Honors have recognized, there's two findings that the court can make in order to uphold summary judgment. That's either that Mr. Prusi no longer was providing services at the time his employment relationship was terminated, or if he was no longer a partner at the time.
Counsel did not even address really in his argument.
That's correct, and it's quite simple in that the partnership agreement, there's ample evidence in the record that he's no longer a partner, but I think the clearest evidence is the definition of termination, which is in the
It
partnership
says it terminates if he's terminated with or without cause. If his employment is terminated, he's no longer a partner.
That's exactly right.
Maybe that's why he didn't make the argument.
That's exactly right. And the other thing that I would note is Mr. Prusi, in his own offensive claim that he made in Oregon State Court against BGC, he clearly stated that he understood the import of an early termination on his promissory note. He stated to the court, on multiple occasions, I considered quitting. However, the circumstances of my hire would have resulted in a 6-figure forfeiture penalty and clawback of all prepaid incentives. All prepaid incentives refers to the promissory note that we're referring to here. And the six-figure forfeiture penalty relates to the partnership interest, which he believes vested into exchangeable units, but that's not the case. If you look at it, his statement to the court is record site 203. If you look at record 280, which is the partnership grant, which I believe he'll address on rebuttal, that actually says that his partnership units that vest over time vest into a post-termination amount. That's an amount that he could be provided after the termination of his employment if he adheres to certain conditions. Mr. Prusi forfeited that amount when he immediately began competing with Newmark and immediately began harming the partnership. I know, as your honors are aware, the interpretations that my colleague here raises render the contract illusory, which is not what this agreement is. There's no circumstance under those interpretations of the agreement where Mr. Prusi would ever have to repay the note, but the note is extremely clear that there are two circumstances when the note becomes immediately payable and due, which the court below found. If there are no...
Your understanding of services is real estate appraisal services.
That's correct. He was hired as a real estate appraiser. He ceased to provide those services.
Thank you.
Thank you.
I did want to address the issue of a partner because the note itself.
Counsel, what about the fact that the partnership agreement states that it terminates following his termination of employment with or without cause? Whether or not it was with or without cause, he was clearly terminated. So why doesn't the partnership interest clearly terminate under its terms?
So first of all, the clause in question as far as when the note becomes due uses a capitalized term of partner, which is actually defined as becoming a partner, not the status of being a partner within the note itself. Respondent's argument was, well, that's not a definition. That's just in the note itself that we refer to a partner as a capital P. In the termination and obligation to repay, it is capital P partner that was used, not lowercase p partner. If lowercase p partner was used under that document, then it wouldn't refer to actually becoming a partner. Once he became a partner, he ceased becoming a partner. Therefore, after that time, his termination of his partnership, or you're no longer part of the partnership agreement, didn't arise. He had already become a partner.
Thank you, counsel. Prospect Resources versus Levant Capital.
What?
Good afternoon, Your Honors. May it please the court. My name is Jeffrey Levine for the plaintiff appellant. This case involves a commercial lease dispute, specifically rent owed under a lease. My client commenced a summary non-payment proceeding in the civil court of New York County seeking rent owed. My client sued one of the two defendants.
What's it now seeking in this action?
I'm sorry, Your Honor?
What's it now seeking in this action as opposed to that action?
About over $400,000.
Is it seeking rent that accrued since that civil court proceeding terminated?
Yes, yes, Your Honor. In the civil court.
Is all of the rent being sought, rent that accrued since the civil court proceeding terminated?
Not all of it. I would say about well over 90% of it. And the part that they are seeking in the Supreme Court action that was also sought in the civil court action, in the civil court proceeding, was rent that the civil court did not rule upon.
Because you didn't amend your petition?
No. The civil court.
Oh, I know. It was a gap between what you asked for and what it awarded.
What happened was, if you break it down in stages, there was the amount sued for in the petition, which was approximately $40,000. That was not ruled upon by the civil court, interestingly enough.
Let me ask you, because let's say you're right about everything, your argument that all the money, since that civil court terminated, is a different proceeding, could not have been brought in that action, and therefore you're not barred. What about that little percentage that was sought in the civil court proceeding? Why isn't your claim res judicata to that little amount?
Right, so res judicata does not apply to that because there was no determination on that on the merits.
Because the court never decided, never denied it or granted it, it just gave a small amount and never explained
Exactly.
why it was doing that.
And interestingly, back when that summary proceeding was commenced, that was before RPAPL 745 changed. Back then, a litigant, a landlord's attorney, was entitled to ask for a UNO order. And that's what we did. We asked for a payment of UNO, and the court granted that. And they directed the tenant to pay UNO post-petition. And it was approximately 3 months post-petition. It amounted to approximately, it was $34,000. The tenant failed to pay that post-petition rent, and I, handling the case on behalf of my client there, filed a motion under 745, which, again, is no longer the procedure. That statute's been amended, asking the court to award a judgment and a warrant, essentially the ultimate relief. The court did award a judgment and a warrant of eviction, but the judgment was only for the $34,000 post-petition rent owed. The court did not address the amount sued for in the petition.
And your argument is that you're allowed to pursue this now. It's not res judicata because you couldn't have brought the majority of the claims in the first instance.
Right. What I'm saying is, worst case scenario, hypothetically, for my client, even if my client were barred from now pursuing the amount of rent that was sought in the petition and was not ruled upon by the civil court, which I'm not saying is the case, but hypothetically, they would still, worst case scenario, be entitled to pursue in the Supreme Court all the rent subsequent to the petition, or stated otherwise, all the rent that they could not sue for in the non-payment proceeding. And I also want to point out that even if res judicata were to apply, which it does not, but hypothetically, if it did apply to bar my client from pursuing any rent against the tenant, it certainly does not bar my tenant from pursuing its claim against the guarantor.
Your landlord, not you just said your tenant.
I'm sorry.
Switch sides.
Not so fast. It would not bar my client from pursuing recovery of the rent owed against the individual guarantor for a few reasons. The individual guarantor was not a party to the non-payment proceeding, which it could not be. And as a matter of law, the guarantor and the tenant are not in legal privity. And I've cited case law in my brief, and notably, the opposing counsel has not offered anything to demonstrate otherwise, other than its position that they are in privity. Thank you.
What about, first introduce yourself.
Good afternoon, Your Honors. May it please the court. My name is Ruben Mirzakhanov, and I represent the respondents in this action.
What about the argument that res judicata does not apply because the civil court did not even have jurisdiction over most of these claims at the time because the rent hadn't accrued yet?
Well, Your Honor, the civil court did have jurisdiction over the rents claimed in this action, and in fact,
Civil court only has jurisdiction for rents that accrue up till the time of the action, not for future rents.
the fact of the matter is that the civil court and the lower court in this action here both agree that had the appellant landlord at the time amended his petition properly, then he would have been able to go after the claim that he's making.
No, because he's has a much bigger claim now for much more time afterwards. So even if he had amended the petition, he still could not have brought the claims he's bringing today in this proceeding.
Because the civil court doesn't permit you to sustain actions for future rent.
Well, it would have been for use and occupancy, and once the eviction occurred, the lease itself was terminated.
Why? Most leases have a provision that allows for rent even after the tenant is evicted, and that allows a tenant to keep collecting rent until the lease ends or it relets, or each lease is different, but almost all commercial leases allow for the collection of rent even after a tenant has been evicted, unless there's an agreement to the contrary.
Right. Well, had that been appellant's position, then he would have commenced his action, sooner than he did. He waited 3 years before commencing again.
Doesn't he have to, if he wants to accrue rent and he hasn't accelerated, and he wants to accrue rent for a longer period, either because he has not relet it and the lease keeps going on, he can't then bring the action earlier, and he's not required to bring the action earlier, as long as he brings it within the statute of limitations. What's wrong with that?
Well, Your Honor, again, our position is that had he properly amended his petition in the civil court, then he would have been able to pursue these claims.
How would he have been able to amend his complaint to assert a claim against the guarantor? Civil court doesn't have jurisdiction in that instant as to the guarantor, correct?
With regard to the guarantor, our argument is that he's in privity with the tenant itself. The guarantor is the director of the tenant. He signed the lease on behalf of the tenant. He hired the
He
attorneys for
couldn't
the
have
tenant.
sustained an action with regard to the guarantor in civil court. Couldn't have named the guarantor as a party in civil court.
He could have pursued the guarantor and the action in a separate proceeding at the time, but regardless, the tenant's claims, the guarantor's rights were properly adjudicated with the tenant at the civil court hearing, judgment. This is a monetary claim for non-payment. The basis of the complaint and the basis of the petition was failure to pay rent.
But the guarantor is completely different obligation than the tenant.
It's a different obligation, but a monetary obligation. And had the tenant been adjudicated liable for an excess in rent and not paid it, then the guarantor would have been responsible for it. And same is true vice versa. Had the tenant been found not liable for the rent applied, then the guarantor would have been found not liable as well. And that is why it's our position that the guarantor was in privity with the tenant, and res judicata should apply to him as well.
Thank you.
Thank you, Your Honor.
Counsel is actually incorrect when he states if the tenant is found not responsible for the rent, guarantor is found not responsible for rent. He's backing his way into the privity argument. The defendant's position is there is privity because the individual operated the business or was a principal. That's not the standard for privity. Privity is, legal privity here is whether the individual, the guarantor here, their rights and obligations are the same. And they're not. They're clearly not. It's a guarantee that he's obligated under. And the case law is clear. The courts have said specifically a guarantor is not in privity with a landlord. So therefore, our claim that there is no privity. Thank you, Your Honors.
213 West 23rd versus Crunch Holdings.
May it please the court, Andrew Goldenberg for appellant. This appeal centers on one point.
Can I just get clarification before you begin? What exactly are you appealing in this matter? Are you appealing the denial of summary judgment against the guarantor only? Are you also appealing any determinations with respect to the tenant?
Summary judgment was granted against the tenant, so we're not appealing that.
Nothing about your appeal has anything to do with any relief with respect to the tenant, because you got summary judgment.
We got summary judgment.
The only issue before us is with respect to the guarantor, and you only bring up the tenant vis-a-vis how it relates to the guarantor's liability.
Yes, Your Honor.
Okay, just wanted to clarify.
So the lower court's finding that there were questions of fact regarding whether, in fact, the tenant, under the provisions of the lease, left the premises in broom clean condition, you're not appealing that issue, right?
Well, I am, because the issue of whether it's broom clean was one of the requirements to relieve the guarantor of its liability under the guarantee. So in order for the guarantor to be off the hook, the premises had to be left in broom clean condition by the tenant.
Broom clean, with regard to what was in the guarantee is different from what broom clean was with regard to within the lease. And the lease the guarantee didn't incorporate by reference the conditions in the lease.
Well, respectfully, Your Honor, I disagree that there's a different meaning of what is broom clean in the lease versus the guarantee.
But it's
Broom clean-
specifically defined in each document what
Yes,
broom
and
clean
each document defines it as, quote, broom clean in section 21 of the lease, and broom clean in the guarantee. Broom clean, we submit, means broom clean. So,
And on top of that, the tenant had a further obligation to not damage the walls when it removed any fixtures and so on, right?
right, so that's another issue, but let me just focus on broom clean. So the authority in the first department makes it clear, broom clean means it has to be left in order, clean, absence of damage.
What
No,
was
So the
wrong
lower
with the
court's
lower
definition.
courts? What was wrong? The lower court made a determination that vis-à-vis the guarantor, the premises were in broom clean condition, and that you determined that by looking at it at the time the premises were turned over, because I know there's a dispute about what happened after that were turned over. What was incorrect
The
about
lower
what
courts,
the lower court held?
the lower court's interpretation of what broom clean is means that if I were to rent out this space, I could take a sledgehammer to the walls, I can break the glass ceiling, I could spray paint everything, but as long as I clean up everything before I leave, it's broom clean. That is not what broom
Isn't
clean
part of the issue
means.
whether all of those things happened after the tenant surrendered the premises and who did it?
No, Your Honor. So the record here was that the purported surrender was on January 25th, 2022. We have time-stamped photographs taken on that very day in the record showing holes in the walls, pipes and pipes coming out of the walls, destroyed mirrors, graffiti, wires hanging from everywhere. Those are photographs taken on January 25th, and we have other photographs taken after that.
So what's
this is
your
the day of the
authority?
purported surrender.
Assuming that's true, what's your authority? Because that would be a bigger definition of broom clean. Normally, broom clean means it's swept, there's no debris, there's no trash. Then there's cases that interpret broom clean to mean exactly that. Why should we interpret broom clean to also mean there shouldn't be any holes in the wall or other things? Where does that come in the depth? Because there is a way to put that in, and it is in the tenant's obligations are more extensive in terms of what it's required in turning it over. But
seminal-
why should we graft that into broom
The
clean?
seminal case of what is meant to be broom clean is from this department. It's the Akron Meats case. In that case, it involved a tenant failing to leave a place in good repair where
Wait,
there
good
was exposed
repair
wiring.
is different than
Where-
broom-
No, but
broom
where there
clean.
was exposed wiring, where there was holes in the wall,
Did the
where there
case
was
use,
other.
did the case use good repair, or did the case interpret broom clean?
Broom clean. This is Akron Meats. This is
A
in our
broom
brief.
clean can be defined by what is in the particular document that dictates broom clean. And if that document has other words along with broom clean and defines broom clean in a specific way, then that's what controls. Versus if in the guarantor's document, the guarantee, it simply said broom clean.
I understand. Well, here's what it says in the lease. It says broom clean in good
Not the
order and
lease,
condition, and
the
the guarantee
guarantee.
says in broom clean condition.
Right.
I interpret that to mean the same thing under this first department's case authority and what a commercially reasonable, two sophisticated parties would bargain for here. This
Then
is
if they meant the same thing, then why would it have been necessary to say in the tenant's lease that there will be no holes and that there will be no?
well, it doesn't say that in the tenant's lease that there would be no holes. All it says is in clean, in good order and condition. But look, may I shift just to the other obligation because you don't have to find that it was left in broom
Well,
clean
it
or
says
not.
tenant shall immediately and at its expense repair and restore the demised premises to the condition existing prior to installation.
Your Honor, that is not, that's a different section. That's section 3 of the lease. The section in the lease that deals with broom clean is section 21. Section 3 of the lease talks about repair and restore obligations that the tenant has. Those repair and restore obligations are additional rent obligations under section 41.1 of the lease.
I just wanted to ask about the factual issue of your client telling the tenant's workers to stop working, stop fixing, stop coming in and saying, stop
that-
now.
We submit that's not a stop working after the landlord comes in and looks at the space and they're taking sledgehammers to the mirror. He said, please stop because you have no protective gear. you have no insurance in place, you're violating OSHA requirements, and then immediately after that, in the record, emails Crunch executives saying, please come and fix this. And what do? They don't come back. There's no note saying, I was denied reentry, you're not letting me in. Let me come back and fix this. Nothing on that. But to your point, Justice Gessmer, on
No. There's not an outstanding question. I'll let you talk about that in rebuttal. Thank you.
okay, thank you.
Good afternoon, and may it please the court. I'm Kirk Brett, and I represent the good guy guarantor here, Crunch Holdings. And I think that the court has already tuned in to the notion that you have to separate the lease from the guarantee, and the lower court did that very effectively and correctly.
Could you describe,
Go ahead.
what's your understanding of the difference in what the condition of the premises had to be in order for the guarantor to be held liable and in order for the tenant to be held liable?
My understanding, Your Honor, is that there is a difference. That the purpose of a good guy guarantee, the good guy aspect of it means I will cause the tenant to leave on time and you won't have to bring an eviction action, okay? And I will.
Surrender's different than broom clean. There's different requirements. And
Yeah.
surrender's one thing, and you do have a good argument about this. Surrender does not require the consent of the landlord because it's not in the guarantee. So that's one argument. But then the separate argument is broom clean and what is encompassed in that. Can the tenant leave with holes in the wall, graffiti on the walls? Is that then as a matter of law still in broom clean condition? Not that, are you trying to argue as a matter of law the premises were in broom clean condition? It's two questions.
Okay, so I will tell you that down below, we argued that at least there's a question of fact. The court.
You argued there was a question of fact,
We
right?
did. We argued that, and the court looked at the photos, and you can look at them too. They're in the record. We have, I think, 30 photos. It's 30,000 square feet of space. And if you zoom in on one thing, maybe you see a little bit of graffiti that happened like the day before. And by the way, the graffiti is a whole issue here because no one knows how it happened. Our understanding is that the landlord was giving access to other
But isn't
people. We
that
have a
enough-
counterclaim against him.
Is that enough to raise an issue of fact? Not that you win in terms of them being denied summary judgment, even if we find an issue of fact, it's broom clean. But isn't the fact that was vandalism and other things, is that enough to raise an issue of a fact as to broom clean? As opposed to what the lower court held, which is that as a matter of law, it was in broom clean.
But the lower court was correct because looking at the pictures, all of the contemporaneous evidence, this place was clean. They brought in 2 cleaning services ahead of time. The place looked fine. Yes, there was some graffiti that happened, but you know what? These kinds of commercial spaces, everyone understands that when you go in afterwards, the next tenant's going to go in. They're going to repaint the walls. They're not going to take the walls as is, right? So everyone understands that. So just don't trash the place with like garbage thrown all over the place, and that is not the image that comes across from the images. That's not the impression that comes across from the images that are in the record and that were contemporaneous. But again, because the lease is totally separate and not incorporated at all, for the same reason that we don't need landlord's consent, also you don't apply the same broom clean standard. There's no reason to do that. I'm just about out. I'll answer any other questions, but
Any other questions? Okay, thank you very much.
thank you.
So, counsel, I'm a bit confused about what your relief is on appeal, right? Because you said that the court granted summary judgment on liability, but that was as to the first cause of action, right? And
That's against the tenant. We're also seeking reversal of summary judgment, denial of summary judgment as against the guarantor.
Right, but there was also denial of summary judgment regarding the tenant, regarding the issue of broom clean. There are questions of fact that you...
The lower court said there were issues of fact, but if I can just shift briefly, because I know I'm running out of time, not on broom clean, but on the other obligation under the guarantee. The guarantee talks about the tenant having to be current on its additional rent obligations. That's in the guarantee.
So the lower court held that there wasn't enough evidence that the tenant wasn't, because they're not moving for summary judgment, you're moving for summary judgment, and held you didn't prove as a matter of law that there was outstanding rent on the day of surrender.
Right, but the additional rent issue is not just about did you pay all your rent or your taxes or utilities. Additional rent also includes, it encompasses all costs or expenses that the tenant is obligated to pay for. That's in the lease because additional rent is
Just
not
tell me
defined
quickly what
anywhere
it
in the
is your-
guarantee.
Your time's up, but tell me, what's your argument, that the damage to the premises constituted part of the rent?
Not just the damage. They removed fixtures, they removed
That's
lockers,
your
they
argument.
removed tiles, they
Thank you.
removed mirrors.
I just wanted to understand your argument.
Those are fixtures that
Okay.
they had to restore under Section 3 of the lease. That's an additional rent obligation. It has nothing to do with broom cleaning.
Thank you.
Thank you, Your Honors.
Ahmed versus Pasternak?
Good afternoon, Your Honors. Meryl Biscone from the firm of Rifkin Radler. I represent the respondent law firm here. It's our position that the dismissal of the complaint was proper because the plaintiff failed to ever timely serve a complaint pursuant to 3012, even after being requested to. The request came after about a week. It took the plaintiff almost 5 months. Separately, the plaintiff failed to offer any excuse for this failure, and it's our position the fact that he is pro se is just simply not enough. The plaintiff also didn't demonstrate the merits of this case. Although not in our record, we asked this court to take judicial notice of actually the case that was on the calendar before this. The plaintiff released UPS totally from any obligation. He signed a general release. That's in the record of
Why does that have any relevance? If your claim is that your client wasn't served, why isn't that the end of it?
Getting to the merits that he had to show on the legal malpractice claim, the but-for, that he had to show that but-for the negligence, he would have had a claim against UPS. It's our position that this release would have totally released UPS, so there wouldn't have been a claim, so he is unable to establish the elements of legal mal.
That's not part of your record.
It's not part of our record. We ask that the court take judicial notice. And even if not, the plaintiff did not establish the but-for element. He would have to show that the board's determination was not based on substantial evidence, which is a heavy burden. Plaintiff didn't even allege this. So it's our position for these reasons that the complaint was properly dismissed against the law firm.
Thank you, counsel.
Thank you.
Castle Village versus Girardi?
She's missing.
You're... Okay, since they're not here, I don't, do you want to look outside? Okay, I'll quickly do one more case, and if they don't come back in, then we'll submit it. People versus Jackson?
Good afternoon, Your Honors. May I begin?
Yes.
Elisa Gamliel for Mr. Jackson, the appellant. In this case, the jury was required to evaluate the April 3rd order of protection that was specified in the final charge and to evaluate Mr. Jackson's conduct in light of that specific order. As charged to the jury, the weight of the evidence did not prove the contempt charge because there was simply no evidence that an order of protection was ever issued on that date. There was no evidence of an April 3rd order of protection. And this case really just requires a very straightforward application of weight of the evidence review. Weight of the evidence analysis is as charged to the jury without objection. The test is whether, based on the weight of the evidence as charged, the jury was justified in finding the defendant guilty beyond a reasonable doubt. And the date of the order that was charged by the court was essential in this case to a verdict that was supported by the weight of the evidence.
Do you contest that there was an order of protection in place?
No, Judge. There were 2 orders of protection that were in place during the relevant time period.
So the only argument is that the date that was charged to the jury was the wrong date.
Well, the argument is that because the court charged a specific order issued on April 3rd that was not either of the dates relevant to the orders of protection that were placed into evidence, that the jury was bound to determine whether or not that order, the April 3rd order, was a valid order. Because there was clearly no April 3rd order, the jury could never have made that
Counsel,
determination.
is a date an element of the crime charge?
It is because, and in fact, the reason that the date is so critical, Judge, is because the jury, as a threshold question, is tasked with determining whether or not there was a valid order in effect. And even the CJI charge requires that the court specify the date of the order. So in this case, the court specified April 3rd, and that became critical. In order for the jury to find that there was a valid order of protection, they had to evaluate the April 3rd order.
We're not permitted in this analysis to look at Mr. Jackson's testimony in and of itself and what he stated in testifying, that he knew that there was an order of protection, yet he contacted the complaining witness.
Right, so the question when we're dealing with an order of protection, which of course, anyone who's ever issued an order of protection knows that this is a technical, that the orders of protection are technical, the precision of the order matters, the terms of the order matter, right? And so whether or not Mr. Jackson admitted that there was an order of protection that was in effect during the time period is sort of irrelevant to the analysis. Once the court charged the April 3rd date without objection by the people, the jury was constrained under the court's charge. That is weight of the evidence analysis. The jury must follow the charge. And so Mr. Jackson's admission that there was an alternate order of protection became irrelevant, really.
So you're saying that even though he admits that there's an order of protection in place, and that's the evidence that comes into the trial before the jury, the fact that the court stated a date different from the orders of protection that were in place, that in and of itself makes it insufficient to have supported this verdict?
Yes, and the reason for that is because before a jury can find the defendant guilty of criminal contempt of an order of protection, they have to evaluate the order. They have to determine first that it's a lawful order. Whether or not there was some secondary order that Mr. Jackson admitted was in effect has no bearing on the question of whether or not the order that was charged to the jury was a valid order and prohibited him from the conduct that he was alleged to have committed.
Now part of the evidence that was submitted was a copy of the order.
Not of an April 3rd order. There were two, and this is a separate problem actually, because there were two orders of protection that were submitted to the jury, right? There was a criminal court order and there was a Supreme Court order. So, you know, there's no world here in which the jury could have on its own sua sponte decided to modify the court's charge and then choose amongst themselves which order of protection they thought was relevant. That would be undermining of the entire judicial process, right? The problem here is that
What relevance do we give to the defense attorney's summation wherein he admits that there was an order in place?
that has no more relevance than Mr. Jackson's admission during trial that there was an order of protection. It is the same problem. The threshold problem is here.
And just to be clear, your argument is that the charge of criminal contempt, an element of that is the date.
If you look at the CJI charge on this, the court is required to specify a date of the order of protection. That's what this court did, as it was required to do. Obviously, the court specified a date that didn't
So an element
exist.
of the crime is what, I'm not asking you about the CJI charge, I'm asking you about the element of criminal contempt, whether the date of the order is an element of that crime that the people have to prove. And when I say element, I mean, is it something that the people have to prove beyond a reasonable doubt?
The people have to prove that there was a valid order in place on...
But they don't have to prove the date on the order of protection.
Well, they do in effect. I mean, ultimately they do, because the jury has to evaluate the order. The jury can't go forward to determine...
Whether on the date the incident occurred, there was a valid order of protection in place. There's no requirement that the jury knows the actual date that it was issued, or the defendant's knowledge of the specific date it was issued to prove a criminal contempt case, just that there was a valid order of protection in place, and the defendant knew there was a valid order of protection.
But the validity of the order is the fundamental question, right? Mr. Jackson can't attest to the validity of the order, nor can defense counsel. So in order for a jury to determine whether or not there was a valid order in place, which is an element of the charge, they have to assess the actual order. Thank you.
Good afternoon, and may it please the court. Matthew Colangelo for the people. It's Correct that Mr. Jackson doesn't have to attest to the validity of the order, but what he did do in this case was testify in his own defense and admit while he was testifying that he knew there were orders of protection prohibiting from contacting the complaining witness and that he violated those orders of protection nonetheless. That was not an accidental concession. It was a strategic effort to obtain an acquittal on the much more serious felony strangulation count. His entire defense at trial and his attorney's entire defense in summation was, yes, I contacted her. I knew I wasn't supposed to, but I did. And I did it because in this day and age, when a woman accuses a man of physical assault, the man starts at a disadvantage. So having made it the entire focus of his ultimately successful defense on the extremely serious felony strangulation charge, he conceded and admitted both in his testimony and through defense counsel's summation that he knew there were orders of protection.
Your argument that's enough to satisfy the weight of the evidence, even without the exact date being before the jury.
Yes, that's exactly right, and for two reasons. First of all, the exact date was before the jury because it was on the order of protection that was admitted into evidence during the trial. But second, on weight of the evidence review, the court only assesses the relative probative force of the evidence if a different finding would not have been unreasonable. And here, it is very hard to fault the jury for concluding that Mr. Jackson did exactly what he told them he did, and is exactly what his lawyers told them he did. So on weight of the evidence review, Your Honors don't even need to evaluate the relative strength because Mr. Jackson said to the members of the jury that he had done it. So I agree with defense counsel that on the weight of the evidence analysis here, the court's review is straightforward. It's straightforward because Mr. Jackson admitted to these facts, his attorney conceded them as well, and the court's minor slip of the tongue in her charge to the jury is no basis to invalidate the jury's verdict. Unless there are other questions, I'll rest on the papers.
Thank you.
Thank you.
What about the fact, counsel, that he admitted that he violated the order of protection and that he knew about it?
That became really quite irrelevant once the jury was charged with an entirely separate date on which the order of protection was issued, and the people failed to object.
Even though there are orders in evidence that do have a date when they were, and they show that they were in place at the time that he contacted this complainant.
Yes, because those orders were not the subject of the court's charge, right? The jury is constrained by the court's charge. This was not a minor typo. This was not something that the jury could have just decided to replace, nor really can the jury ever do that, right? We know that. We don't empower the jury to modify a court's charge, but this court is empowered in a case like this, where you have a jury who clearly didn't pay attention to the date. These are things that wash over people, things that people don't pay attention to, but in an order of protection case, this is critical. The order of protection itself is critical. That is where the case rises and falls.
Thank you, counsel.
Thank you.
Castle Village versus Girardi.
I'm sorry if you called me before. I was downstairs with the TV, but I didn't hear my name. I'm sorry. So first of all, I am processed, so apologies. I'll do my best. So I appealed an injunction that has been partially reversed since then, with the court correctly recognizing that the plumbing issue was fabricated and that the business judgment rule does not protect the co-op because they singled me out and harassed me. So while this acknowledgement is crucial, it suggests that the injunction was actually obtained in bad faith, and it was not totally, it was partially reversed, and it doesn't really cover the fully remedy that the harm that they caused to me, and key aspect of the order remain intact. So I submitted to the court the new, it was from last week, the judge order. So the plaintiff actually were granted an injunction to put a thick gas pipe only in my apartment. There are 500 apartments through my ceiling, blocking forever the renovation that I bought this apartment for. Actually, was just 3 months after I moved. And I now can't build the office I need for my work. I need a private office because I deal with confidential material because I work for the NIH, for the government. I'm a doctor. And now I'm working from my bedroom. That is not ideal because of that. But the main thing is that 2 big lies were told to the court to get this injunction. First of all, the plaintiff attorneys lied directly to the judge, to his face, and that's in his court, in his injunction, about a boiler and the fact that the building was not going to have any heat during the winter. And I mean, I agree with the judge. I would have done the same thing. I wouldn't have left the whole building without gas. But actually, the boiler was running on oil. They picked me because I was new to the building and I knew anything about the boiler. A nice neighbor told me about that. So that was a big lie that they made just to mislead the court. And if that lie was not enough, for 20 months, they have been harassing me with a leak that the HPD proof is inexistent. They have been harassing me with entering my apartment to destroy my bathroom with the police, with the marshals. I have an FBI clearance because of my job, and I hear a police car, and I freak out. They made me feel unsafe in my own home, sending me nasty letters that in 3 days they would come and destroy my whole bathroom that I have to pay for using their own contractor. So there were so many irregularities in this that I called the HPD that actually demonstrate, and it's in the videos that I submitted, that is fraud, that is a scam. And the judge was able to see that the only evidence they support, and they actually have the burden of the proof, and they haven't done that. The only things that they provided are these 5, 6 affidavits of a manager that never set foot in my apartment and even talk about cracks on my bathroom floor and mold growing out in the bathroom downstairs. The owners of the apartment downstairs had nowhere to be seen. I've been there many times with my husband, myself, with my plumber, knocking, asking them to see that. They refused. They never submitted an affidavit, but according to the manager, they live in an uninhabitable situation. There's no expert report. They only submit a bill for a full bathroom renovation, and the contractor there is nowhere to be found. I sent him emails, text, nothing happened. So
You have time on rebuttal. Thank you.
Good afternoon. May it please the court. Kristen Pendergrass from Seyfarth Shaw on behalf of plaintiff respondent Castle Village Owners Corp. So from the outset, this appeal should be dismissed because it's taken from an unappealable paper from the court. Procedurally, what happened in this case is that in October of 2023, a preliminary injunction order was issued that enjoined the defendant from interfering with the Castle Village Owners Corp., which is the co-op that owns the complex that her apartment is located in, enjoined her from interfering with their completion of a gas line replacement project, which was not done solely in her apartment, but was done in all 500 apartments throughout the complex. The defendant was the only resident who wouldn't allow the work to continue through her apartment, and then also enjoined her from interfering with the co-op's investigation and repair of a leak that appeared to be coming from the defendant's apartment bathroom. That injunction was granted. No notice of appeal was filed. At the time, the defendant was represented by counsel. The gas line work was completed. That is done. That has been that portion of the injunction was complied with. When the defendant also allowed an initial investigation into the bathroom to determine the specific source of the leak. Investigation was done by the in-house plumber for the co-op. The source of the leak was determined to be the shower pan, but then defendant would not allow the repair of the cracked shower pan to go forward, and then proceeded to file a motion, again, well represented by counsel at the time, a motion to vacate or modify the preliminary injunction order. That motion was submitted by order to show cause, was brief, was denied. Defendant then immediately filed a second motion, again by order to show cause, this time proceeding pro se. The court declined to sign that proposed order to show cause, and that is the paper that is being appealed from today. But as you can see in our brief, and as I'm sure the court is aware, there's no appeal to be taken from a court declining to sign a proposed order to show cause. To the extent that the appellant in her reply papers seeks to sort of sweep in the issues with respect to the initial preliminary injunction and the initial her initial motion to vacate that injunction or modify that injunction. None of those materials appear in the record. There's no notice of appeal filed. That they're not properly the subject of this appeal. And then with respect to the recent order that was issued, again, that renders her appeal, that has been entered into the record. I believe it is on, it was uploaded to the e-court, or the NICEF filing for this case, that effectively renders the appeal academic at this point because the initial injunction order has been modified. We just disagree with the defendant's characterization of what the court found in that order. The court determined there are issues of fact as to, based on evidence that came up after this appeal, or after the underlying decision in this appeal was issued, that basically there were questions of fact as to whether the specific source of the leak, whether the bathroom was the source of the leak, because of evidence that came up later, that came up subsequently. But that order that was issued about a week and a half ago effectively obviates the initial motion that or supersedes the initial injunction order, and so any request to modify the initial injunction order becomes moot.
In
And
addition
this is
to being non-appealable, it's also moot at this point.
I'm sorry?
In addition to being non-appealable.
In addition to being not appealable, it's academic, it's moot at this point, yes, sure.
Thank you.
Your Honor, so what I'm appealing is that the judge denies considering my motion to dismiss, to change considering it a duplicate of the one that my previous lawyer submitted. However, my motion to change the injunction had 17 pages and 32 exhibits compared to the one submitted previously from my attorney that actually he was dismissed for failing to represent me correctly, that had only 6 pages, a seventh including the signature, and only 11 exhibits. So certainly what I submitted that has all these HPD records, etc., was not a duplicate of what was submitted previously. So that's what I'm appealing. I'm not a lawyer, but from what I read, any court order that actually has some harm associated can be appealable. So this judge actually got it wrong. My motion was not a duplicate of the one previously described.
Thank you. Thank you very much.
Thank you so much.